City, Missouri. Jack is the senior partner in a several partner firm in Kansas City. It's Cochran, Tyree, Oswald, Barton, and McDonald. His practice is devoted exclusively to family law, and he is a family law expert in the state of Missouri. Jack is the chairman of the family law section of the Missouri Bar, and he sits on the Missouri Bar Board of Governors, a very prestigious position. Jack, I think the message, even though he's from Missouri and not practicing in Texas, it was my experience when I practiced law that there are several universal aspects of family law, and I think that he has a message that we all can gain from listening to him today. So I'll let him get started. What we'll do is he'll go, we won't have a break. He'll go for a while, and then we'll open it up to questions if anybody has questions. Jack?
If I move around, is that camera going to miss me?
I don't know.
I told Roger as we were coming up that he had called in to my office and indicated that they're going to videotape this, and my secretary comes in and she says, "I have bad news." And I said, "What's that?" She says, "Well, this thing you're doing down in Texas," she says, which nobody can understand why I was going for a $10,000 honorarium, but anyway, she says, "They're going to videotape you." And I said, "Well, so what? Been videotaped many times." And she says, "Yes, but she says you're going to have to delete all of your obscenities." And Roger assured me that I wouldn't have to. So, I don't know what on earth I'm doing here. You know, what a lawyer from Kansas City, Missouri is doing in Houston, Texas, talking about divorce law defies my imagination. But anyway, we'll struggle along here, and yeah, we've got chalk here. Roger has indicated to me basically that this is an extraordinarily scholarly, academic group of students, and I'm an extraordinarily scholarly, academic type of lawyer. So I have some citations here that I want to share with you. You want to get these down. Imagine most of you have read that. 75 Wyoming 9/11's another favorite of mine, and then 314 Puerto Rico 311. You've got all those down. You now have the scholarly stuff for today, and we'll leave all that stuff behind. As Roger indicated, I do absolutely nothing but domestic law, and that is absolutely not to be indicia of intelligence. Anyone who limits their law practice to handling nothing but divorce cases has to be a masochist. It's, like multiple enemas per day, You don't do this sort of thing. Once you've limited your law practice to family law in a little town like Kansas City, Missouri, at least by Houston standards, well, you get a, quote, big reputation. And so with the big reputation, what that means is all the small folks can't afford you and all the big folks can, so all you get is now is big problems. So you have real large enemas. And that's what I do for a living, and it's really crazy, so I doubt if I have too much to share with you it's going to be of any benefit. The topic that I've selected today is the same topic I used for a one-week seminar in Honolulu in November of last year, and that we did it for about 5 days, 3 hours a day, so that we could all get a good tax write-off. We're going to do the same thing in 2 hours today, so it's going to be flying rather rapidly. The law school that I was speaking for on that occasion wanted kind of a hot topic to get people to encourage to go all the way from Kansas City to Hawaii, and so I selected the topic, the divorce worm, to eat or be eaten, and that's what we're going to talk about again today. Most of you will be smart enough to go to work for corporations, and you're not going to need to know any of this. But for those few of you who are silly enough to do domestic work, there may be a little bit of benefit in 20 years of practical experience. For those of you who just do general trial work, there may be a little bit of benefit, because a lot of the things we're going to be talking about are just practical, everyday things. Being an effective divorce lawyer is just like being an effective lawyer. It's not too important that you understand anything about the law. It is extremely important that you understand how the system works and how to work the judges. That is very, very important. And by far and away, the most important thing is how to handle the clients. At some stage in your career, you will get a phone call from some poor, forlorn housewife who will say to you, Mr. Cochran, incidentally, this phone call will come at 3 a.m. in the morning. Mr. Cochran, my husband just hit me over the head with a Schlitz bottle for the 700th time, and this is it. And I'm going to tell you what to say to that lady. What you say is, be in my office at 8 o'clock tomorrow morning. If you don't say that, then they will reconcile by the afternoon, and you're going to miss this large fee that you otherwise would have received. Once you get the client in the office, there's a couple of things you can do, and this is applicable to family law or anything else. I don't know why I have those notes. I don't need those. Once you have the client in the office, there's two things you can do. You can have your client sit down in your office, and you can ask them a large number of very complex questions, such as, what is your name? Where do you live? When were you born? What is your Social Security number? What is your husband's name? Where do you work? Do you have any children? Where were they born? Are they in good health? What grade are they in? Well, I don't have time for any of that. So when you pop into my office, or hopefully the way the system really works properly is when the client calls in, we make the appointment. We send this little interview sheet out to them, and this little interview sheet has 9 pages. And they complete that and bring it with them, or if it's more of a rush type thing, they come into the office and they either fill this out in the reception room or in a private conference room, so that I know basically everything there is to know about their case from the very beginning. That does a lot of nice things. Number one, I don't have to find out what their name is. I can look down, and I'm pretty quick. I pick up those things pretty good once it's printed. And then you can fly right into the thing. Next thing is, it's in the client's own handwriting. And thirdly, and most importantly, the information that I get on my little blue information sheet is all honest, because they don't know how the game is played yet. Once they learn how the game is played, then everything changes. The home that was worth $125,000 the day of the interview that wifey wants is worth $80,000 when we're getting ready to go to court, because she knows it's going to go in her column. So this is all good, honest information. Incidentally, any of the forms I refer to, I brought some extra forms for any of you who are genuinely interested in this sort of silliness, and if I run out, I'll be glad to send them to you. More importantly than the information sheet is what happens when you first walk into your reception room. This is a first impression type thing. When you hit the reception room, there's some things that you should be very cautious of. The first thing you want to be very cautious of is when you look in there and you see your client and they have their mother or their father sitting with them. This is a very bad sign for everything except attorney's fees. Because if you have mom or dad come back and sit in on the interview, you will not get any honest responses. You do not hear about the client's adultery from the client when mommy is sitting there with them. You know, you just don't get that. And the menage a trois that occurred 4 weeks ago, you're not going to hear about it with dad sitting there. You're just not going to get that sort of information. So what you want to do is you walk in and you introduce yourself to the client, and they say, oh, this is your dad. And, hi, Dad, how are you? And Dad gets up, and he wants to come in, and you got to sit Dad down, and you say, Dad, I'd really love to share with you, but in the state of Missouri, we have a little law called the attorney-client privilege, and if there's a third person sitting in on the conference, then I've waived the privilege. And I would hate to be called as a witness against your daughter, wouldn't you? Oh, yes, Mr. Cochran. Well, listen, why don't you stay here and have a cup of coffee, and I'll chat with your daughter for a few minutes, and then I'll come out and I'll talk to you. And I really don't want to talk to him at all, except I will want to talk to him about a check, because that's the real reason he's there. So you leave him out in the reception room, and then you go in and you can talk to your client, and you can find out some honesty and some truth, which is very helpful in the legal business. Second thing I want you to be very cautious of is the client who, when they stand up, have a briefcase with them. This is a bad sign. I do not know why it is a bad sign to have domestic clients with briefcases, but it is a bad, bad sign. If they have 2 briefcases, I would consider not taking the case. If they have 2 briefcases and a mother or a father, just turn around and walk out and say, "I'm sorry, you have the wrong office." It is very important, once you sit down with a domestic client, instantaneously someone is going to take charge. And it's either going to be you or it's going to be the client. Now, I don't understand all this modern psychology about body language. That's way too modern for me. But I have a few little things I've picked up on. And one thing I've picked up on is when the client comes in, and when they start talking before their ass hits the seat, that is a bad sign. That is a real bad sign. They're very, very nervous, and they want to take charge. And really and truly, I have to be in charge. I'm going to be the captain of this ship, and there's absolutely no question about that. So when the client starts talking on the way down, then I just have to shut them up real rapidly, very nicely, and say, "You've been so kind as to fill out all this 9 pages of Greek. If you just sit there and have a little coffee, I'd really like to read this information, and this will help me help you." And so they'll usually, that particular client will say, "Fine," and I'll look down and they'll start talking, say, "No, you don't understand. You just have to sit there for a little while and let me read this." And usually by that stage they will, and you can get through it. Done a lot of things when I do that. First of all, we now know who's running the case right from the beginning. Secondly, I know the whole story because everything is in here. I've given them an opportunity to tell me everything, all sorts of fascinating information, things that I'm really interested in. I'm interested in what went wrong with this marriage. I'm interested in the number of children. I'm interested in who's going to have custody. I'm interested in what went wrong. I'm interested in what the assets are. I'm real interested in what the assets are. And I'm real interested in the bank accounts and the savings accounts and the CDs, because those all tell me a lot about my interest in the case. Now, it is extremely important that the client know from the beginning that I am not going to pick that client up and carry them for the next year of their life without their help. The client has to know right from the beginning that we are going to do this thing together as a team. Hand in hand, arm in arm, we're going to go through this mess together. You have to practice law for quite a few years before you finally learn one of the great truths. And one of the great truths is that we as lawyers do not make the facts. We as lawyers do not make the law. We take the facts as they come, we take the law as it comes, and we do our very best. We are not the ones who had the pleasure, if we're representing the doctor, of having the adultery with the nurse for the last 7 years. You know, he did that. He did that. And no fee that he'll ever pay me will relieve what he did. And there are a million other examples. If you are representing the person who has been beating the child for the last 11 years, there is no check on earth that's going to solve that problem. The client needs to know that up front. 95% of all cases filed in this county, domestic cases, are settled. I did not do a private study of that. Roger told me that on the way in from the airport. The same thing is true in Kansas City, Missouri. 95% of the cases are settled. Now, you begin that settlement process when you meet the client out in the reception room, and it ends the day you go to court. If you ever let a client out of your office with unreasonable expectations as to what they're going to get, you'll never get your case settled. And if you never get your case settled, you can never exist as a lawyer, because it takes too long to try cases. I don't know the system in Houston or Dallas or San Antonio, but I know the system in Kansas City and St. Louis, and I know that you don't try cases, you stand in the hallways wanting to try cases. That's how the system works, and I would imagine it's exactly the same way here. So you have to settle cases, and the way you settle cases is by having tried cases and being good and getting good results. But your client has to have reasonable settlement expectations. So when the client comes in and you finally get through your little information sheet and you start chatting about their life, and they tell you what happened at 4 o'clock in the morning last night, and you get to that place in the conference when you say, well, what would you like for me to accomplish for you? What are you expecting? And the lady says, well, I want the house, all 3 cars, all the money, all the stocks. I want him to pay the debts. I want custody of the children, X amount child support. You don't have maintenance, but you eventually will. I want X amount maintenance or alimony, and his left testicle. That's what they want. That's what they want. That is exactly what they want. And if you were sitting where she was, you'd feel the same way too. And at that stage, we have to start talking about that which is deliverable and that which is not deliverable. You know. It is extremely important that the client understand what you can do and what you cannot do. The man who wants to achieve custody of the child, he doesn't even know the child's middle name. He's never been to a PTA meeting. He's never been to a parent-teacher conference. He's never once taken the child to church. He's probably never babysat the child. This man is not going to achieve custody. The fact that his wife got caught out in the park doing such and such with the policeman doesn't make any difference. Doesn't make any difference. You're not going to win that case, and you better let somebody know up front. It gets real dangerous when they start pulling their checkbooks out and they start wanting to write large checks because they're wanting you to walk on water, and you cannot walk on water, and they might as well know it up front. So it's extraordinarily important, I think, in every area of the law, but especially in family law. It is such an absolute emotional pressure cooker that the client have extraordinarily reasonable settlement or trial expectations. It is very, very important that you paint the worst possible scenario for the client. If the client knows the absolute worst that can ever happen to them, they'll never be disappointed in trial. And that's the truth. That's the truth. I think if you talk to one of my clients after they left my office and you said, did Jack tell you the worst that could happen? I don't know if they'd recognize that I had done it, because I usually get them pretty well pumped up, feeling good about life before they leave. But I'm going to get that point across of all the bad stuff that could happen so that they walk out of there with reasonable expectations as to their future life. Being an effective domestic lawyer is about, 20% knowing what you're doing and 80% psychologist. And I don't do any counseling, but an awful lot of it is taking these poor, poor people, and I'm not talking economically, I'm talking emotionally and mentally, who come into your office as absolute wrecks, and you start a rebuilding process. And an awful lot of what I do, it's not that I achieve custody or that I achieve 70% of the marital assets or whatever I do. It's that when I leave that client walking away from the courthouse, we have them started on a new life. And that's real, real important. One of the things that's rather important, I'd kind of like to chat about at that opening interview, is the subject of attorney fees. Most of you are probably not interested in the subject of attorney's fees, so if you're not interested in that subject, this would be a good time to take a break, go to the bathroom, whatever you want to do. Those of you who are interested in the subject of money might want to sit around for a few seconds. It is extremely important that you and the client have a clear understanding of attorney's fees, and that is a very difficult subject to bring up, especially for a young attorney. You're interested in it, and the client's interested in it, but the client is scared to death to mention it, and you're scared to death to mention it. And there is a very interesting way to lead into that subject, which is to say, would you like to talk about attorney's fees? Oh, yes. Yes. Well, so would I. Let's chat about attorney's fees for a little while. I don't know what this case is going to cost. I really wish I could tell you that my fee would be such and such, but I don't have any idea. Because first of all, I don't know everything there is to know about your case. I've never met your wife, and I certainly don't know who your wife's attorney is going to be. And these are a lot of variable factors. I can tell you in this particular type of case that the absolute minimum my fee will be is X. I can also tell you that my hourly rate is Y. I can also tell you that there are 3 other lawyers here in my firm who do nothing but domestic work, and there are a large number of paralegals who also specialize in domestic relations, investigators who specialize in domestic relations, and all of their fees come substantially lower than mine. We're going to do our best to delegate as much of the work we can to those lower people to keep your fee as low as possible. And then we talk about the fact that we expect them to pay us, not their spouse or someone else. We look to the client to be paid. I don't know anything about the law in Texas, but in Missouri, for decades, the husband automatically got stuck with the wife's attorney's fees. That's no longer the case in the state of Missouri or in most states, so it's very important that the female clients be aware of that up front. It's also very important that the clients be very aware that you are very, very interested in the subject of money. Because if they get the impression that you're legal aid, you will be legal aid. And if you want to be legal aid, that's okay, but you might as well understand it up front. If the client understands that you are very concerned about the fee, that is important. Probably 90% of all the battles between lawyers and clients occur over the subject of attorney's fees. If you're going to have a problem over the subject of attorney's fees, I want to suggest to you that the best time on earth to have it is the opening conference. I don't ever have a problem on attorney's fees, but it's because we get it out on the table up front, reduced to a written agreement, signed that day, copy delivered to the client along with a 3-page letter, which I send to every new client the same day they retain us. And it has all sorts of interesting, simple information contained therein. And there's one little paragraph on the subject of attorney's fees that says, "We enter into a written agreement with all clients in dissolution of marriage matters. A copy of your agreement is attached. Please read it very carefully. And if you have any questions, feel free to call me." We also give the clients a little pamphlet called Attorney's Fees in Family Law Cases. You may think that this bizarre, crazy, bald guy from Kansas City is uptight about attorney's fees. There's a lot of truth about that. This is the difference between Jaguars and Corvairs, you know. Well, I've got all this stuff I refer to. I'll be glad to give you a little copy of. Anyway, we now have decided to take this case, and we have a real clear understanding, and we probably haven't fallen in love with the client, but hopefully the client has fallen in love with us. And that's real important. We have this very close working relationship. Now we're going to tell the client what we're going to do, and we're going to start projecting effort. Clients like lawyers with action. They like to see you do something. So, if they're paying you whatever they're paying you per hour, they might as well see some action. So do something. Pick up your dictating machine and dictate a letter to the son of a bitch. You know, she's told you for an hour and a half that he's a son of a bitch. You might as well communicate with him. Or communicate with the son of a bitch's lawyer. You know, whatever you've got to do, start projecting effort. Pick up the telephone. Call the other lawyer. Show that client you're going to do something. They start to relax when they see that you're in control. Then from that instant forward, continue to project that effort. Photocopies are extraordinarily inexpensive. If you can't afford a photocopy machine, buy onion skin paper. Copies are cheap. Paper is cheap. Postage is cheap. You send client a copy of every single thing you do. Every letter that goes to the other attorney, a copy goes to the client. You've got this fancy little IBM computer. It will belch out 3,411 interrogatories in 3 minutes, and you're sending them all to the son of a bitch to answer. Don't disappoint your client by not letting her see what you're making him do. Now, when you send out 3,411 interrogatories, your opponent is going to photocopy them and send them all back to you, and she's going to get to answer them. So you may want to use a little discretion about that. We'll talk about discovery a little later here. You do a trial brief for the court. I mean, you are really proud of it. This is a work of art. You didn't do it, your law clerk did it, you know, but you're proud of it. You know, you got that kid from that law school down in Houston who is smart, and they did that great job, and there's 13 pages of brilliance there. You don't just give it to the judge and the other lawyer. The judge is never going to read it. Give it to the one person who really cares, and that's your client. You send clients appellate briefs. You know what they do with appellate briefs? You know what clients do with them? They put them on their coffee table in their living room. Yeah, it's right there with Architectural Digest. And I mean, they say, look at what my lawyer did. It only cost $7,000. You know, you got to share this stuff with them. Every piece of paper that comes in from the opposition sends you some huge motion, and it's giving you ulcers. You might as well share those ulcers. Have a copy made for your client and send it to the client. You get a rubber stamp that says, for your information. An ideal case, I think, an ideal case, now I've never had an ideal case, but an ideal case is where every day when the client goes to the mailbox, there's a blue envelope from Cochran, Tyree, Oswald. I mean, that lawyer, he is a working son of a bitch. You know. Now, usually, I don't read that stuff that the other side sends in, but my clients all do. That's called projecting effort, and clients love it. Clients love it. They like to know that you're working, and that's how you show they're working without picking up the phone and calling. You don't want to talk to the client. You're too busy to talk to the client. Clients tell war stories and they tell sad stories, and you're too busy to hear those things. So you just keep pumping this information to them. When the client leaves this first interview, they need a little homework assignment. So I have a simple little checklist that I give to them. Just check off what I want. Deeds, tax returns, statements of property, income and expense statements, car titles, life insurance policies, etc. This accomplishes a couple of things. Number one, you got to have all this stuff, and you got to have it up front. Secondly, it keeps the client busy for a couple of weeks, and there's a lot to be said for that. You kind of get them out of your hair for a while, and they can go do their homework, and it also gives you a chance to start processing the case. Okay, let's assume now that we have a happy new client, and we have instigated some domestic litigation, or we are responding to some domestic litigation and preparation for a trial, which is really to say we're really preparing for a settlement, but the only way you get a good case settled is to be ready for trial. So we begin the discovery process. With the advent of the photocopy machine a few decades ago, the discovery process became more complex because people can now photocopy your garbage and send it back. It's just a matter, when it says at the top, petitioner's first interrogatories to respondent, if your opponent can afford three things, some of that whiteout stuff that the secretaries use, and a typewriter and a photocopy machine, that which took you 3 hours to draft, they can ship back to you in 3 minutes. So the whole use of interrogatories takes a great amount of discretion. You don't want to send an interrogatory to an opponent that you don't want to answer. So when your client is the black hat, you've got the cardiologist who's been bedding down the scrub nurse for 7 years in the surgery suite. I would suggest that you not ask questions about those sorts of things. Don't talk about, have you caressed, fondled, da-da-da-da-da-da. You don't ask those questions because you don't want to answer them. And your opponent is not near as good a lawyer as you are. They don't have those books full of interrogatory questions and all that stuff on that fancy word processor, so don't give them that ammunition. Don't send out questions that you don't want to have to answer. Asking interrogatories is important, but there's lots of books on it you can pick up, figure out how to do it. Answering interrogatories there are not books on. That takes practical work. One thing you never do is let the client answer the interrogatory. This is very dangerous. This is very dangerous. Clients will tell the truth. And this is scary. This is scary. Now, you're an officer of the court. None of us are going to suborn perjury, but it's just a matter of kind of cleaning things up a little bit. So, there are lots of ways to get around answering hard questions. Let me tell you one of my all-time favorites that is absolutely incredible. Now, this suggestion is worth whatever your tuition was for this semester. When you get hit with an interrogatory question that is the one that almost throws you into cardiac arrest and does throw your client into cardiac arrest, and it's buried in 75 pages of interrogatories, and they want to know, were you at the Owl Motel on 50 Highway in Kansas City, Missouri, the night of January 4, 1983 at 4:30 p.m.? The answer to that is N.A. for not applicable. You say, how do you get away with that? Well, the way you get away with that is your opponent is as busy or busier than you are. So when they go, they're flipping through the interrogatory answers, and they only look for the ones that have been answered. That's all they do. And they hit an N.A., they just keep going, see? If you forget the N.A., just leave it blank, and they'll keep going on that. Your success rate on that will only be about 95%. It's amazing. On the other 5%, you get a phone call from your opponent saying, you didn't answer question number 47. Oh, that damn secretary. Let me get an answer out to you. And then if you've left it blank, you put N.A. and send it back. Okay. Those are the very reasons that interrogatories aren't the wonderful weapon that we used to think they were. A much better discovery device is the motion to produce, which I assume you have. Okay. When you use motions to produce, you get the real McCoy, not somebody's version. And especially in the domestic relations arena, the motion to produce is wonderful. You get fascinating things, like you get income tax returns. And you say, how is an income tax return fascinating? Only when it's not the return that was really filed. See, you write the IRS and get the real thing, and you let the other guy produce the one that he had his CPA change. If you think that is effective on cross-examination, you're right. Another fascinating thing you can get with the motion to produce is canceled checks. We all sin. Some of us sin more discreetly than others. Most of us sin and use checks AT&T, and Visa, and MasterCharge, and American Express to leave a trail of our sins behind us. People actually go to the Owl Motel in Kansas City, Missouri, which I would not highly recommend, and they actually write checks for their 30-minute stay for $14. They really do that. They also go to Saks Fifth Avenue on the Country Club Plaza in Kansas City, and they buy fur coats for the scrub nurse, and they write a check, or they charge it to American Express. They also carry on loving, caring relationships by long-distance telephone and leave a trail behind them. Motions to produce get those things. Now, as is true in every area of the law, with the good news comes the bad news, and sometimes you get hit with the motion to produce yourself. There are also ways of dealing with those. If you get a motion to produce that says, please present to my office on such and such a date your canceled checks for the 3 previous years. And so you have the client bring them in. You're not going to go through them. You're going to have your paralegal or that whiz-bang law student from that law school down in Houston go through them. Okay? And you're going to tell them what to look for. Look for checks to Saks Fifth Avenue. Look for checks to the Owl Motel and all similar things. And if you find those nasty things, what do? Are you going to pull them out? No, that's not playing the game according to the rules. We're not going to do that. That's kind of suborning perjury. We're not going to do that. But we do not have to present these checks to our opponent in chronological order. They wanted the checks, we'll give them the checks. We'll give them 9 boxes of checks. And they won't be in order. In fact, the only thing they will look like is your Uncle Harry's basement that hadn't been cleaned out for 17 years. That's the way you give them the checks. They can sort them out. They ask for them, we give them to them. I handle a lot of major domestic cases that involve closely held corporations. And it is very, very difficult to ascertain the value of a closely held corporation. How much is a cardiologist's medical practice worth who's making $450,000 a year? In order to ascertain that, you have to have the financial records. When I represent the cardiologist and I get the motion to produce, and the motion to produce usually comes in with 47 questions and 317 subparts, what I do is I give them everything they ask for. But I usually will call them and say, you filed this motion to produce and we have the information for you now. You asked that we present these at your office, but the records are really a little bit too heavy to move. We have a company in Kansas City called Belger Cartage. And Belger Cartage, they move major items, like huge computers and things like that. Said, you guys might want to call Belger Cartage and have them move this stuff out to your office. Well, how much stuff is there, Jack? Well, I think there's 4 rooms full. And they say, my God, we're set for trial in 2 days. And I said, yeah, I didn't know why you wanted that stuff, but they'll never find it. That's being street smart. That's all there is to it. Once you get burned like that, you don't make that mistake twice. Let's talk about the real discovery weapon, which is the deposition. When I first started practicing family law 20 years ago, nobody had ever heard of taking a deposition in a divorce case. And perhaps this might be a good place to get rid of it. Hope y'all got that Puerto Rican citation down. Might just move away here for a second to talk about, before we talk about domestic depositions, and this is kind of a fun topic, to talk about divorce in general and the dollars and cents. We're going to talk about the human emotion later. Let's just talk about the dollars and cents. A classic comment that every practicing lawyer has heard, anybody who ever goes to the courthouse has heard the statement from the judge, "Oh, shit, it's only a divorce." I mean, that's, you know, that should be emblazoned across the courthouses in America. "Oh, shit, it's only a divorce." You know, see, our divorces, our judiciary, they want to handle important, significant things of real substance, like rear-end automobile injuries that involve $5,000, $10,000, or Visa versus Harry Jones, $317, or Rogers DWI, you know, big things. I want to describe for you an all-American divorce case, okay? Simple case. We're not talking the $450,000 cardiologist. We're talking, you know, Mr. and Mrs. USA. They've got 3 kids, ages 2, 5, and 7. And he makes $40,000 a year. And she makes $7,500 a year. Not major dollars. They have some assets. They have a home. It has $40,000 equity. As a result of inflation, which means they probably don't live in Houston. They've got a car with a couple $1,000s equity. They've got $2,000 equity in cash value and some life insurance. This $40,000 job is down at the local automobile manufacturing plant. And lo and behold, Dad's got $25,000 in his retirement plan. He didn't know that. He didn't know he had a retirement plan. And they've got $5,000 of furniture. And let's give them $5,000 worth of debts. So we'll just mark off the furniture. Let's talk about how much money is involved in this divorce case. This case involves 0, 0, 2, 4, 5, 7. Something like, I may have missed some math there. $69,000. We have a $69,000 case, right? Wrong. We gotta have to deal with the modest subject of child support. Usually I would use the example of maintenance or alimony in Missouri, but you don't have that. So we'll just talk about child support. I'm going to guesstimate that the child support on $40,000, we'll just pick a round figure, probably be around $750 a month. So we have a $69,750 case, right? Wrong. Because you pay child support 12 months a year. $9,000. Smart law student wouldn't have had to do that. They'd have known it. So we now have a $69,000 plus 9, $78,000 case, right? Wrong. We're going to be paying $9,000 a year, at least in Missouri, until age 21. So I'm going to forget the fact that we got a 7-year-old and a 5-year-old, because that child support's going to get bumped up every 2 or 3 years, and I'm just going to deal with 19 years of child support at $9,000 a year. How much is that? Anybody know? We got a CPA out there. How much? Close to 108,000. Okay, we now have, let's just round it, we have a $200,000 lawsuit. That is exactly what you're talking about. That's not phony baloney dollars. That is real money. And honestly, it's on the low side, because what's really going to happen is after 3 years, Mom's going to come back to court. She's going to get that $750 kicked up to $900, and 3 years later, it's going to go to $1,100. And we're going to end up, we're probably going to be dealing with $250,000 or more. You can go down here, hit the suburbs of Houston, go up and hit the suburbs of Dallas, and you talk to the everyday practicing lawyer and say, when is the last time you handled a $250,000 case? The average guy, if he's honest, the average lady's going to say, I've never handled a $250,000 case. Do any divorces? Yeah. Did you ever handle a $250,000 divorce? No. Well, let's look at your last file. And they're handling them every day, but they're handling them as though they were the $350 Macy's versus John Jones collection matter. And they're not. They're big ticket numbers, and here we're describing a very small case. So, we understand we have to do discovery. We have to do discovery right. And the great, great tool of discovery is the deposition. There are very few things in life that are more frightening than having your deposition taken. And that is especially true in a domestic case. As I look around this room, most of you are very young. But I'll bet you there's not a person here who'd like to come up here and sit down and have me cross-examine them for the next 45 minutes about the private parts of their life. I don't want any of you cross-examining me, you know. And here you're talking about somebody who's 55 years old, and some smart-ass lawyer is going to sit there and pump them for about 3 hours or maybe 3 days about what's going on in their life. And that's real heavy-duty stuff. So, if you're going into depositions, it takes an absolutely incredible amount of preparation. I can take a superb deposition with absolutely no preparation. And the reason for that is that I have taken, I would guess, in the thousands of domestic depositions. And I have never once gone in without preparation. But I could do it. But I wouldn't be near as good as if I have sat down with my file the afternoon or the evening before and decided exactly where I'm going and how I'm going to get there. I prepare for the domestic deposition exactly the same way I prepare for the domestic trial. Is I do not go into court with shotguns. I go in with rifles. I'm going to fire one shot. I know exactly where I'm going. Lawyers who fire shotguns lose. Lawyers who fire rifles win. You have to know where you're going. Probably 95% of your cases are going to get settled or won the day of the deposition. Right then. Trial date's 4 months off, but you win it right there because you're going into that deposition and you know exactly where you're going and you know exactly how you're going to get there. It is absolutely flabbergasting. It is amazing what your opponent will do while you're taking his or her client's deposition. It is amazing what they will do. What they do not do is sit there and intensely look at you and listen to your questions and make timely objections. What they prefer to do, if you do this in the firm library, which is where most depositions are taken, most lawyers have fascinations with strange things. One of the things that most lawyers have a bizarre fascination with is Martindale Hubbell. Now, how anybody could be titulated by Martindale Hubbell, I've never known. But this is their only time to pick up that big, fat volume on Texas and see how all my law school classmates are rated. Has so-and-so got a C yet? So-and-so's got a B, you know? This is really hot stuff. I don't know what they read in there, but they like to read Martindale Hubbell. They like to read law review articles. Why you do this during a deposition, I've never known. But that's what they do. They read their files. They read Penthouse magazine. They read all sorts of strange things. They look out windows, they take naps, they drink coffee, they get up, they go to the bathroom. They do all sorts of things while I'm doing surgery on their client. I hope none of you ever do that. Most lawyers like to sleep during the initial portion of the deposition. I would suggest that if we're ever opponents, that you ought not to sleep during the first 5 minutes of the deposition. Probably going to have the scalpel out, unless I know that you're the kind that sleeps late in the deposition. And then we'll just go in and we'll ask all those hard questions like, Mrs. Jones, Would you state your name, please? You know, and you slowly lull them to sleep. I prefer to go for the juggler right from the beginning. Well, how do you go for the juggler in a divorce case? Well, you got to think about it, and there's no patent remedy for what works in every case. But you have to decide what are the strengths of your case and what are the weaknesses of your case. Let's take a fact situation. Let's give me the cardiologist who's been having this little discreet affair with the scrub nurse in the surgery suite. And he's in major league trouble. We have had his practice valued by 2 independent experts. One of them has placed a value on it at $3 million, and our own guy places a value on it at $2 million. Okay? We got major league problems here. It is the cardiologist's belief that his wife, soon-to-be ex-wife, should receive her 1981 Chevrolet station wagon and nothing else, because she's done nothing for him to get him to where he is. If she had done anything for him, he would not have had the affair with the scrub nurse. Now, this is a case that causes me some concern as his attorney, because I don't know how in the world I'm going to escape with only one testicle. This is a twin testicle case. We're going to lose them both. Now, what are we going to do? Well, what we're going to have to do in this case, and under the law of Missouri, and I don't know if it's this way here, in Missouri, we say that we consider the conduct of the parties during the marriage. Not just the bad conduct, but also the good conduct. So perhaps since my client's bad conduct is so bad, and I'm going to lose on that, maybe I should focus on his good conduct. Well, how am I going to do that? This woman came into this deposition so scared, so frightened, so full of hatred for her spouse, and hates me 10 times more because I am the low-grade smut who agreed to represent someone who would bed down the scrub nurse. It just shows what kind of a person I am that I'll take on those kind of cases. So how am I going to slip up on her? Well, the way I might slip up on her is like this. I don't have to ask her name for the first question. I know her name. I know who she is. I know where she lives. I don't have to have that stuff. I might just say, Mrs. Jones, would it be okay if I called you Mary? That kind of shocks her, and she says, sure. I look her in the eye and I say, Mary, do you love Bill? You know what her answer is? A little tear starts to form up here in the eye, and that lower chin starts to quiver, and her blood pressure is going through the ceiling, and she says, yes. And I say, Mary, you and Bill shared some wonderful years together, didn't you? Yes. You and Bill worked awfully hard all those years, didn't you? Yes. And on and on and on. And they've been married 31 years. And the first 30 years were heaven. And I just proved it. Now, the last year is bad. So if I have to try that case, opening statement. Opening statement. I filed the divorce. I go first in Missouri. Say, Judge, my client, I walk over and I put my hand on his shoulder, is, as you know, the leading cardiologist in the city of Kansas City. He has saved thousands of lives. But, Judge, I want you to know that my client got into some serious trouble about a year ago. and he had an affair. And he's not proud of it, and I don't condone it, and I know you don't condone it. But I want you to know that he did it, and I don't want this court to have to take 3 days' time to hear about that, because you know he did it, Judge. But I also want you to know that for the first 30 years of this marriage, this man has been a pillar of our community and a pillar of his family. And his son, who's going to Harvard, and his daughter, who's going to Yale, da-da-da-da-da-da. That's the way you play them. You know, that's what you call making chicken salad out of chicken shit. Okay? That's the way it's done. There's no reason to talk about the adultery. They don't need to bring that gorgeous scrub nurse in as a witness. I don't want to see her. You know, the damage has been done. So when you go in to take that deposition, you've got to know where you're going. You got to have a plan, and you can't use the same plan in every case. I am famous in Kansas City, Missouri for the question, Mary, do you love Bill? Hell, everybody knows that's one of Cochran's old bag of tricks. It goes down great in St. Louis, but it's no good in Kansas City. You got to go with the flow. But you got to think about where you're going. You don't do everything the same way in the practice of law. In my area, there are 3 or 4 law firms in the greater Kansas City area that have renowned family law attorneys. And I know everything they're going to do in every case. Most of them are superb, fantastic lawyers. Most of them have not had a creative idea in the last 35 years. They do it all the same way every time. It's very easy to prepare your client for deposition when you know every single question that your opponent's going to ask. So you got to know where you're going. Now, let's turn that around a little bit. This is a good subject for about a week, but we're going to dust it off in about 5 minutes, the subject of domestic depositions. But let's now assume that you're on the receiving end of the deposition. You're the person whose client's deposition is being taken. You're the person who wants more than anything else on earth to be reading Martindale Hubbell. Because you are bored. I mean, this is pain. This guy, not only his first question is, what is your name? He follows it with, how do you spell it? You know, this is pain. Okay, your job is to protect your client and stay awake. And it's not always easy. I have one very, very good opponent, very good lawyer. It takes him about 8 hours to take a deposition. He takes a very thorough deposition. But it's 15 no-dos to get through it. It's really painful. And it's hard, but he's a good lawyer. And I know at some stage he is going to go for the jugular because he is a good lawyer. So I've got to beware. You have to prepare the client. You have to sit down with the client for hours. You cannot do this for 5 minutes in somebody's reception room. It takes hours. We have a letter that we send out telling clients, somewhere I have it here, depositions. Send this 3-page letter out telling clients how to get ready for their deposition. And then you sit down with them and you get them prepared and you tell them how to answer questions and how not to answer questions. The questions that can be answered yes are answered yes. Questions that can be answered no are answered no. Questions that we don't know the answer to are answered, I'm sorry, I don't know. And also, courts do not require us to be computers. And we do not have to recall where we were on January 1, 1977. At 2:30 in the afternoon. We didn't get to the Owl Motel until 4. So when they ask that question, it's a valid thing to say, I'm sorry, I don't remember. I'm sorry, I don't recall. If you don't know, I have never once suggested a client commit perjury in a deposition. Just not going to do that. But I am going to make my opponent ask the right question. And we do not help our opponents ask questions. This is a very strange, bizarre thing for human beings. We all help each other communicate. When I was up here struggling with those financial figures a few minutes ago, there were a number of you out there who would have liked to have said, Cochran, it's $78,000. We do the same thing when we communicate. Somebody asks you a question, you go home, and your spouse or your mom or your dad or somebody says, well, how was that lawyer who came in and talked to you today from St. Louis? And you'll say, oh, he wasn't from St. Louis, he was from Kansas City. They're the guys that won the World Series, last year. We help each other communicate, but you don't do that in a deposition. When they say, Dr. So-and-so, have you been committing adultery with your secretary? No, I have not. It was the scrub nurse. You don't volunteer that. You don't volunteer it. And you can't imagine how lawyers ask the wrong questions, and they do that because they don't prepare. So you got to have the client prepared generally. Then you have to have the client prepared specifically, because you know there are certain very complex, difficult questions that are going to come their way, and you've got to have them programmed how to answer the question. Now, there are going to be questions asked during the deposition that you didn't anticipate. For one thing, there are things that have occurred during the marriage that you're not aware of, and those are the ones that really frighten you. You didn't know about such and such. Your client has been embarrassed to tell you about that. So, the way you handle that is this. You tell your client in advance that there are absolutely wonderful restroom facilities in this building. And at such time as you get hit with the question that you don't want to answer, your response is, Mr. Smith, where is your restroom? And he says, well, it's just down the hall. I say, yeah, it is time for a break. And we all get up and we walk out. And what are you going to do if you're the opposing lawyer? You're going to say, wait just a minute, you can't go to the potty? No, she's gone. She's down there going to the bathroom, and I'm out in the hall drinking coffee. And I guarantee you, we're going to chat before we go back in there. There is nothing that can be done to prevent that. Videotape is the one effective way to prevent that. But that doesn't happen very often. I talk to my clients during depositions. Most lawyers don't. Most lawyers sit there and just let them sink. I don't. They ask a question, and I say, Mary, do you understand that question? Now, what Bill's trying to find out is da-da-da-da-da-da-da-da. And I tell them the answer right there. Is that what you wanted to know, Bill? Yeah, that's what I wanted to know. You have to talk to them. Sometimes you have to say, Bill, shut up. You don't like to say that, but occasionally when you have the client who just can't quit talking, you've got to shut them up. You can kick, you can poke, you can pinch. You want to be next to your client where you're close enough to assault them. Because that is the only way you can control some clients. And that deposition, they can die. That cardiologist can drop $1 million on the table in that deposition. Or somebody may drop the custody of 3 children on the table in that deposition. And it's got to be done right, because you live and die with that deposition. You can't be too well prepared. I want to talk for just a few seconds about what I call informal discovery. This is the discovery that you do on your own, or usually that your client does. The cardiologist's wife comes to see you rather than the cardiologist. And you know this is a big ticket case. This is major league money. Or it's the president of the bank's wife. Or the president of the local grain elevator. Or whatever. And what you really want are some financial records that never exist 24 hours from now. once they know that there's going to be domestic litigation. And so when the cardiologist's wife, when you discover that she is a part-time bookkeeper at the office, you send her down there that night to get the stuff. I don't care if she runs 7 photocopy machines till they die. You get that stuff that night. It's what I call informal discovery. Another type of informal discovery is when we hire the local off-duty police officer to sit outside the cardiologist's surgical suite at 2 o'clock in the morning. That's informal discovery. There's lots of things like that that you can do if you try to exercise some of those creative things going on in your mind. One thing I love to do is to get my opponents to give their case away. And a wonderful way for them to give their case away is in the middle of the deposition, and you've already been there for about 4 hours. You say, "Mrs. Jones, are you getting tired?" She says, "Yes." And I say, "So am I." You look at her lawyer, and you say, "You know, I could go on here for hours. But, you know, I think I could get all this stuff from her doctor or her employer. Why don't we just have her sign an authorization for release of this information?" And he says, "Oh, yes, please, let's do." Because he's very tired, and you're very tired, and you know you're not getting any information. This lady is wonderfully prepared. Her lawyer's done a phenomenal job. You've spent 4 hours in the deposition. You spent 7 hours getting ready. You're going to bill X dollars for it. Huge amount of money. You paid the court reporter, and you haven't gotten 13 cents worth of information. And so you act like you got to go make one of these authorizations. You had it ready 2 days ago. You go out there and you slip this little authorization out there on the table, and they sign it. What have they done? They've just opened up their whole life to you. I hate seminar speakers who tell war stories. And I'm only going to tell 1 or 2 today, and this is number 1. It's probably my all-time favorite because it really tells the story. A couple of years ago, I was representing a gentleman who, on a 1 to 10 scale of marital misconduct, had achieved a 47. He held an extraordinarily responsible position. There was a lot of money at stake. And his major piece of marital misconduct came in the area of wife beating. We're talking heavy-duty wife beating. He admitted this, and she certainly admitted it. And the case ultimately was going to come down on which one of the 2 of them were telling the truth. That was the only issue. Everyone admitted and agreed that he would, about every 6 months, beat her to a pulp. The question was why he beat her. He asserted that he beat her because she enticed him into beating her. She denied that. Without going into all of the details of the case, suffice it to say that you will stipulate and agree with me that the whole case ultimately hinged on whether or not the woman was truthful. If she was a truthful person, we were dead. If she was, as my client asserted, a congenital liar, we were okay. I took the lady's deposition, hours, hours, and hours, that she told me about all these dreadful, terrible things he had done, a little bit of S&M thrown in, you name it, they had done it. And I had major league problems. Got her to sign an authorization for me to review all of her medical records. Under Missouri law, unbeknownst to her husband's attorney, those medical records also extended to her psychiatrist, who of course was an MD. And so after the deposition, a couple of days, we quietly walked into the psychiatrist's office, and quietly showed him our authorization, told him we had a little case going and we just need to check a few things out. He went, got the file, photocopied the file, handed us the file. We go back to the office and read it. First page of the doctor's notes. Client's major complaint. I have never been able to tell the truth. End of case. End of case. Walked into the opposing attorney's office and said, I have something I'd like to share with you today. Have the medical records here from Dr. So-and-so. And he said, who's that? I said, that's your client's psychiatrist that she's been in therapy with for the last 3 years. Oh, yeah, that's the one she goes sees because of all those massive beatings and all that mental blah, blah, blah. I said, that's the one. I want you to read the records. He only read the first line. He said, that doesn't look good. I said, it gets worse. That conversation happened at about 9:30 in the morning, and at 4 o'clock that afternoon, that case was over. Settled, finished, done with. I don't know what that evidence would have been in court, but that lady was never going to give me that opportunity. Authorizations for release of information are just an incredible, phenomenal weapon. You can get the same thing in personnel records. It is amazing what you find in personnel records. It is just flabbergasting. I would suggest you be very cautious about giving out those sorts of authorizations. I'm going to skip over the subject of settlement because we're running out of time. I want to talk just a little tiny bit about trial and post-trial. You prepare for a divorce trial just like you prepare for any trial, which means you prepare. You do your homework, you do it early, and you do it right. And before the trial, you develop a strategy. You assess the weaknesses of your case, you assess the strengths of your case, and you play down the weaknesses and you play up the strengths. And you know exactly where you're going. I find in every divorce case there are two very significant and important witnesses, the husband and the wife. Everybody else is frosting on the cake. They're just not important. A major step toward winning a divorce case is to walk into chambers before the trial and casually mention to the judge when he says, well, Jack, how long is this just a divorce case going to last? And I say, Judge, I don't know. I've got about 45 minutes worth of evidence. I said, I saw a bus pull up out in front of the courthouse, and my opponent was driving. He had 17 witnesses. I don't know if they're all going to testify, but they are all out there in the hall. And there are lawyers who try cases like that. Now, I'm now 85% toward winning my case. I mean, that judge, he doesn't particularly like me, but he hates my opponent. And he's going to call the flip. The judge is. So you go in with the thinnest possible number of witnesses. You present that testimony in a direct, concise way. If the case is worth it, and most of them are, you go with an opening statement, and that opening statement ought to last about a minute and a half. You have good, clean, concise, demonstrative evidence. Are there any judges in the room? Good. I hope no judges ever see this videotape. Most judges are either dumb or lazy. That's true, and most judges will agree with that if you're talking about other judges. Okay? There are some wonderful judges. We all know that. There are a lot of judges that are really hyper lazy. And the guy who wins is the guy who makes their work the easiest. And when your opponent puts in 737 pages of exhibits, and you have one exhibit that is 1 page in length, that is your, we're only talking in this particular case about cardiologist. We're only talking about one issue, and that's the division of the marital assets and debts. He has two choices this weekend. Kansas City Chiefs are playing, and he wants to go to the game, but he promised those people he'd have a decision by Monday morning. He took all the exhibits home with him, and he gets them all out there on the kitchen table, and he's got his wife there helping him. And you don't think that happens, but it does. And they sort out all the exhibits. Here's the petitioner, 713 pages, and here's the respondents, 1. Well, I think I'll start with the 1 first. And you pick it up, and you look at it, and you say, that looks pretty fair. And you go over here, and you just kind of peel through that stuff. You say, this looks pretty good. Go to the Chiefs game. If you think that doesn't happen, you haven't tried near as many lawsuits as I have. I can't tell you how many times that decrees come out just like my exhibit. And it's not because I had the right side. It's because we did it smart. You know, the old deal about KISS, K-I-S-S, keep it simple, stupid. Boy, that is a winner. That's probably more valuable than anything you're going to learn in any constitutional law class in this law school. Or any other class in this law school. Including this one. Keep it simple, stupid. Make it simple. Make it clean. You know, put the witness on the witness stand for 13 minutes. They don't have to be on there for 13 hours. If you've got another witness, put them on there for 3 minutes. You're going with cross-examination. You don't have to go with 4,000 questions. You may have 3 questions. You may have the best question of all. One of the most effective cross-examinations I've ever done, and I've done it many times, is this lady right here is the witness. And she has just ripped my client apart for 3 hours. And I don't have any defense to any of it. Okay? I mean, there's nothing I can say. This gal is a wonderful witness. But the judge, you know, he went to sleep after the first 2 hours. So they only got 1/3 of the way there. So the judge turns to me and he says, Mr. Cochran, cross-examination? And I say, yes, Your Honor. And I push away from the counsel table and I walk over there and I've got a legal pad and I throw that sucker down and I walk over here and I look at her. No questions. There's nothing I could have asked. You know, she would have killed me. But the judge, he's been asleep for 2 hours. And he says, man, she must not have said a thing if Cochran didn't ask her any questions. You keep it simple. Closing arguments. I can't tell you how many times I've seen well-tried divorce cases tried, and then the judge says, counsel, would you like to make a closing argument? There's $200,000 at stake. They could give a brilliant 45-minute closing argument in a $3,000 neckbender case. But they grew up with the shit, it's only a divorce mentality, and so they say, no, Your Honor, no closing argument. Now, to me, that is just scrapping everything that we lawyers stand for. You know, we're there not as CPAs. We're not there as expert witnesses. We're not there as the old barristers or solicitors, whatever they called them in England, that sat back in the dusty stacks. We're advocates. We hold in our hands at that moment the total life and the total destiny of that family. And you tell me that I'm not going to make a closing argument? Wrong. Wrong. And I won't have to spend 3 hours the night before getting ready for that closing argument. I've lived with that case for 9 months, or maybe a year and 9 months. And that closing argument is going to come from the heart. And it's going to be tight, and it's going to be concise, and it's going to tell the judge exactly how to rule and the only way he can rule. And it's not a difficult thing to do. Every person in this room, I swear, every person in this room can do the same thing. You don't have to be an eloquent speaker. You don't have to be a debater. You don't have to be an appellate advocate. You just have to be somebody who was silly enough to accept employment in that case back in November of '86 and who's lived with this agony for a year and a half, and you got the feelings right in your guts, and don't leave them there. You know, you got to share with the court what the court should do. The court doesn't know what to do. The court, you forget, typically hates divorce cases. And they're really looking for an easy answer. It's what they really, really want. And you're just the person to give it to them. Let's assume the verdict is in. What do we do then? The first thing we do is explain to our client what happened. In a personal injury case, when the jury comes in for the defense and you represent the plaintiff, your client has an idea what happened. In a criminal case, when you are the prosecuting attorney and they hold for the defense, the state knows what happened. You know. But in a divorce case that frequently involves 13 different issues, we're arguing about custody, visitation, child support, alimony, who gets the house, who gets the car, who gets the retirement plan, attorney's fees, da-da-da-da-da-da. And the judge goes back in chambers and spends 5 or 10 minutes writing out his decision. Your client typically doesn't know what happened. And sometimes you may not know what happened. But you better be a lot quicker on your feet than the client is. What you do is very important. What I do is I take my client right down the hall into a conference room and I tell them about the tremendous victory that we just achieved. Occasionally, we don't achieve a tremendous victory. Occasionally, we lose. Remember, we didn't make the facts. We didn't make love to the scrub nurse. And that may be the time to remind the cardiologist, "Oh, Doc, I wish you'd have stayed away from her." And he says, "Yes, I should have, Mr. Cochran, because as good as you are, if I hadn't have done that, I wouldn't have lost everything I own, would I?" And I said, "No, Doc, you wouldn't have. You'd still be rich if it wasn't for her." The client really honestly does not know what happened, and you have to go educate them. You have to educate them. One thing that I jumped across that I like to talk about, and we'll hit it real quickly, is the subject of attorney fees at trial. This is a real fun area. I assume in Texas either party can request attorney's fees from the other side? Okay. Well, we still have that in Missouri, too. Gloria Steinem has made some pretty major headway into that, but she hadn't completely brought it to a conclusion. And so we still have a situation where the wife, who has no money, no assets, no anything, can petition the court for her husband to pay her attorney fees. Attorney's fees today in a major divorce case can be a very major amount of money. The days of divorce cases being handled for $300 or $600 or $800 or $1,200 are history, though I dare say if I was to pick up the Houston newspaper, I could probably find some fine advocate that could handle something less than the filing fee. You can't get that done in my office. And a very common thing is your opponent will come up to you and say, the trial is basically over, and your opponent says, I need to put some evidence on regarding my fee. Okay. I would like for you to stipulate to my fee. Well, what is your fee? And you see them get their pen and pencil out. They go through some figures, and you see the amount of hours, and it looks reasonable to you. And you say, what is your hourly rate? And they say $50 an hour, and you charge $150 an hour. You say, you know, I think that's fair. I'll stipulate to that. You also get the flip side of that when you have something that's outrageous. In that case, you have to put your opposing counsel through the agony of getting on the witness stand. That, too, can be fun. I tried a case a few years ago in Independence, Missouri, Harry Truman's hometown, and my opponent was an absolutely superb lawyer, a lady who's been practicing for probably 30 years, who is a brilliant lawyer. And she got on the witness stand in this horrendously complex case in which her client was truly, truly insane. More than the normal. This lady was truly insane. She used to remodel the house by removing the drywall while her husband was at work and spray painting the windows black. She had a tough case. She got on the witness stand because I would not stipulate to the reasonableness of her attorney's fees. And this was many, many years ago, and she indicated to the court how many hours their firm had spent on the case. I saw the judge write it down. She then testified that her hourly rate was $75 per hour. And at that time, in our part of the world, that was a reasonable hourly rate. In fact, it was even a low hourly rate. And I immediately turned to the court because I knew what was coming, and I said, Your Honor, I would stipulate to Miss So-and-so's hourly rate as being extraordinarily reasonable for a lawyer of her excellent qualifications. And she thought, what's going on? And she went on through her little spiel, and then it was my opportunity for cross-examination. And I said, Martha, I've reviewed your time records here, and it would appear to me as though you did about 8% of the work on this case. Is that true? She said, well, something like that. And I said, and the rest of the work was done by your young associate, Miss So-and-so. Yes. I said, how long has she been practicing? And she said, oh, about 11 months. I said, well, this must have been her first case. Well, yes, it was. Is she with your firm now? No, she's not with us any longer. I said, and she spent 317 hours. Yes. And what is her hourly billing rate? $75. And I said, her rate is the same as your rate? Yes. I said, oh. I said, would you agree with me that there are a certain number of things that you could do more rapidly than she could? And she made a major league mistake. In fact, it was about a $7,000 mistake as the verdict came down. She said, no, it would take us both the same length of time. And I then looked at the judge and did what is famous in Kansas City called the Jack Cochran eyes disappear into the head act. And the judge, literally, his chair, he just spun it around like this, and you could just see his shoulders rocking up and down. Major league problem. You can get on the flip side of that attorney fee thing in the domestic relation case, and that can also be fun. That's when your opponent is cross-examining you as to the value of your services. It's typically smart to stipulate to the value of the other person's fee. You may argue till hell freezes over about who should pay it, but it's very dangerous to cross-examine your opponent because, strangely enough, opponents tend to be smart. They also tend to be real uptight about attorneys. So, if you can avoid that confrontation, I would highly recommend it. Fairly recently, I was trying a modification case. I don't remember what we were arguing about, but the divorce had happened long ago, and I don't even remember if it was child custody or whatever it was, but it was a bitter battle, and the other lawyer had made an opening statement and was all fired up about the law and had read from kind of the Missouri Bible on family law, which is produced by the State Bar Association, our Family Law CLE volume. And he had read from the chapter on modification law. And that was kind of the major thrust of his case. And he kept throwing that throughout the case. And he wouldn't agree to my attorney fees, and so I had gotten on the witness stand and had testified, as we do in Missouri, as to what my qualifications are. And, you know, it's a chance to make a nice little speech about how wonderful you are and all these honors that you hold and all this stuff. And so the guy comes up on cross-examination. And he must have been a relative of Martha's because he made some mistakes. He says, "Mr. Cochran," he says, "I acknowledge that you are seen as an expert in the state of Missouri as an expert on divorce law. But I want to know, do you have any expertise in the area of modification law?" Well, to me, a divorce and a modification are about the same thing. I'd never thought about it like that before. And I thought about it for a moment, and I said, "Well," I said, "I've never thought about that before." I said, "I do recall that you quoted in your opening statement from the Missouri Bar Family Law CLE chapter on modification." He said, "Yes, sir, I did." And I said, "I wrote that chapter." Now, this is not good trial preparation. Same judge, same chair, same shoulders, you know. It was wonderful. Someday you'll be a lawyer and you can go out and give speeches, and it's wonderful to tell about your victories. You forget about your defeats. We don't talk about those. I'm going to give you a few minutes for questions if you have any. Before I do that, the last parting shot I want to leave with you is this thought. If you are ever so naive, so silly, so stupid, so ludicrous as to accept employment in a divorce case, I hope that you will have the good sense to recognize that in spite of how people like Jack Cochran can stand up and to a degree make light of it, that you do control people's lives. There is nothing in the world. I wouldn't begin to ask for a show of hands in this room today of how many of you have gone through a divorce, or how many of you have a brother or a sister or a mother who's gone through a divorce, or grandparents. But I want to assure you, from having handled thousands and thousands of divorce cases, that there is nothing in the world more traumatic than the explosion of a family unit. It is by far more traumatic than the death of a spouse, than the death of a child, than the death of a parent. It is the most traumatic thing that any human being will ever experience, because it is full of guilt, it is full of hatred, it is full of pain, and it is the most agonizing thing that any human being ever has to go through. And when you're the person who is handling that, you are carrying those people's lives. In addition to that, you are carrying their financial destinies, and you are probably carrying the lives of their children. We who practice domestic law like to talk about the trials, and the depositions, and the clever interrogatories, and the clever things our private investigators do. But most of that makes for good law school seminars. What we really do, and what I really do for a living, and what I am really good at, and what I hope you'll really be good at, is if you're handling this kind of a case, if you can take that client and sit them down in your office and diffuse the hatred, diffuse the hostility. Don't become their counselor, but get them in the hands of a counselor. Get these people talking. Maybe, just maybe, you'll pull off a miracle, and you'll put this couple back together happily and permanently forever. That is the ultimate achievement of a divorce lawyer, is for there never to be a divorce. That is the ultimate achievement. The worst thing you can do is to put a Band-Aid on the marriage and send them back together only to have them come back. And somewhere in between, there's a divorce. But you have to recognize that you are handling the most precious commodity that God has ever given us, and that is the lives of a family. And I would suggest to you that that is a sacred obligation. Thank you for the opportunity to be with you. Thank you. If you have any questions at all, I'll be happy to field them. And also, I've got all sorts of stuff up here that you're welcome to look through after the class that we give out. And if we run out, I'll be